Hello. Today I want to talk about a decision that we recently received here at Luskin Albertson from an administrative law judge of the State Tenure Commission in a case that we handled for Madison District Public Schools. And the opinions were pretty important in that they clarified some of the changes in the Teacher Tenure Act that came into being in 2011. Specifically in this case, two teachers filed claims of appeal after a layoff notice was given, and the opinions held that layoff and recall, as well as teacher evaluations, an evaluation in and of itself, is not under the jurisdiction of the Tenure Commission to hear and not worthy of essentially a claim of appeal. And what had happened here was after the teachers received their notice of layoff, they filed claims of appeal with the Commission, essentially claiming that they were laid off improperly because the layoffs were based upon faulty evaluations, and that the evaluations weren't conducted properly and weren't conducted in accordance with Section 1249 of the Revised School Code. We answered the claim of appeal and then filed a motion to dismiss the case, claiming that layoff and recall were removed from the Tenure Act by the 2011 amendments to that Act. And specifically, the changes in that Act placed layoff and recall now within Section 1248 of the Revised School Code. And that if a teacher has a problem with their layoff and recall decision, they need to file a claim in court under Section 1248 as that section allows. The ALJ agreed and found that the Commission no longer has jurisdiction to deal with layoff and recall. Moreover, as it relates to the evaluation of the teachers, we also argued, that that an evaluation in and of itself is not a decision of a board that a claim of appeal can be filed on, and that there must be some further cognizable harm that results before a claim can be made. And the judge also agreed. And specifically within that, the judge held that layoff and recall is under Section 1248 is under Section 1248 of the Revised School Code, and that if there's a problem with a 1249 evaluation, that can be reviewed by the court reviewing the layoff and recall. Furthermore, the appellants in this situation also argued that the evaluations and the layoff were done in bad faith, essentially a subterfuge to discharge the teachers. And again, we argued that all of that can be wrapped up in a 1248 case, and the ALJ agreed and found that the essence of this case deals with layoff and recall. Layoff and recall is no longer a part of the Teacher Tenure Act, and that all of those are now handled under Section 1248 of the Revised School Code. We here at Luskin Albertson were pleased with the decision and pleased that to represent Madison schools in this matter.